Our panel this afternoon is about the role of international law and governance in assisting the settlement of disputes in the South China Sea. And we have here three outstanding lawyers as panelists. We have Professor Oxman, Richard N. Hostler, Professor of Law, University of Miami. We have Professor Robert Beckman, he's Director of Center of International Law, National University of Singapore. And we have Mr. Jimenez, Executive Vice President of the Asia Pacific Basin for Energy Studies. Their detailed bio have been distributed, so I think I should not go into the detail. But may I invite Professor Oxman to speak first?
Thank you very much. It's a great pleasure to be here. I had suggested to the organizers of this conference that since there are two of us here, and since Professor Beckman is from the region and deeply familiar with the particular issues, that a logical way to divide this up would be for me to speak generally about the law of the sea rules that are relevant in the opinion of many people, although apparently not Ambassador Hill, and then Professor Beckman will proceed with the application of those in the area. Is that still satisfactory? I just want to check. Okay. I do want to notice that since there was a reference to pre-Westphalian civilizations this morning, I'm not sure what the implications were, but I'm sure that there are inferences that would charm many people in Beirut or Athens or Rome or Tenochtitlan or Cusco, to cite just a few. I do want to make the point that I think it would be exceedingly dangerous to go down that route, and I think the dangers in going down that route are probably more apparent to political scientists than to lawyers. The other is that there have been references to international law and to the Law of the Sea Convention, and that is accurate. The Law of the Sea Convention is not the totality of international law by any stretch of the imagination. But I do want to make the point, which seems not to have been made yet, that the Law of the Sea Convention itself, in its last preambular paragraph, addresses that relationship when it says that matters not regulated by this convention continue to be governed by the rules of general international law. The clear implication is that matters that are regulated by the convention are, at least insofar as the parties are concerned, are regulated by the convention. The second point I want to make is that after many, many efforts to achieve this, going back to the Harvard research projects in the 1930s, this convention has achieved what many people thought was impossible, and that is close to universal agreement as positive law, that is, as treaty text, not a resolution at some fancy resort, as positive law, agreement on the basic rules with respect to the law of the sea that govern, we should remember, 2/3 of the planet. There are very few coastal states that are not party to this convention. One of them is the United States of America, that does, however, take the position that the convention's substantive provisions, not its institutional provisions, are generally declaratory of international law. As I tell my students, all the legal work in that statement is being done by the word generally. But the United States, for those of you who follow this, has in fact been quite active in trying to make sure that the behavior of other states is compatible with that in the convention. The In fact, in cases before the International Court of Justice, states, which, beginning with the United States, that are not party to the convention, have not stressed that. There was recently an exception in the Nicaragua-Colombia case, and Colombia did not do very well in stressing that point in that case. All right. The convention is huge. It's designed to lay out the basic rules of public international law for a gigantic area in which there are major security interests, major economic interests, major environmental interests, and on and on. The fascination of this topic is that it covers almost everything that you could imagine. I made an attempt, and there will be a large number of sins of omission here, I hope no sins of commission, to reduce this for purposes of those who are not experts to 8 pages. And you have that. Now, this is 8 pages out of, 300 and some odd? So there's a lot missing. But I did feel that some of you might, in fact, like to see what the, what the text on some of these points says, and so I handed it out for that purpose. The focus, when you think of the South China Sea, with respect to the law of the sea, the focus is on coastal state jurisdiction because the major disputes are between different states that are claiming coastal state jurisdiction in the area, with one exception to which a reference has already been made, and that is the differences between the United States and China regarding the conduct of certain activities in the exclusive economic zone. But in fact, the starting point historically in post-Westphalian international law, which I had always thought countries wanted to join, but in any event, the starting point is the Grotian attitude of the freedom of the seas, which gradually triumphed in large measure because Great Britain decided to enforce it, having changed position on that issue, and was a reaction to limitations on the notion that all of the seas are free. The first limitation was that there really ought to be a narrow band along the coast in which the sea is not free. I find the law enforcement reasons for that quite persuasive. I find the standard security reasons for that to be utter nonsense. An army is not going to refrain from attacking your land territory because it has to violate your territorial sea to get there. But be that as it may, the narrow band emerged, and it initially emerged as 3 nautical miles. Some people say that's because of the cannon shot rule. I can't believe that people didn't understand that military technology changes and that all maritime empires going back thousands of years enforced their rights at sea using ships, not using fixed cannon that can't be moved from one place to another. I think the reason for the 3-mile rule was simple fact that distances at sea were measured in fathoms, that if you wanted to give a little bit to the coastal state, it would be the number 1, and 1 fathom under most calculations is 3 miles, but there it is. That remained controversial, and there never was agreement on whether it was 3 miles or it was something more. Spain, for example, for a long time in the Western Hemisphere claimed 6 or even 9 miles, and there were differences of opinion on that question within relatively narrow limits. The floodgates on this question broke in 1945 from a very, very unusual source. In the history of the law of the sea, a point made by Professor Beckman earlier, your dominant maritime powers always wanted maximum freedom of the seas and narrowest possible coastal state control. The United States of America, having emerged in 1945 as the dominant maritime power, did exactly the reverse and declared its jurisdiction over the continental shelf beyond the territorial sea and simultaneously recognized the right of other coastal states to do so. The United States didn't make clear precisely how far the continental shelf extended. This was, of course, in response to the possibility that there was oil in the continental shelf. What happened, however, is that very quickly other countries, beginning in Latin America, took the position, if the United States can claim the seabed out to Lord knows where, now if it suits its interests, we can claim the waters if it suits our interests. And then Chile made the argument, since we have very little continental shelf, we're going to claim a mileage limit to 200 miles. And that began a process in which the, if you will, the quasi-consensus on the Grotian system started to collapse. An attempt was made to fix that by the International Law Commission, 1958 Conference on the Law of the Sea, which did succeed in having 4 excellent conventions, but it did not stabilize the law of the sea on the key issue, which is how far does coastal state control extend, and therefore how far towards the coast are there freedoms of the sea. Between the first conference and the second conference, and I think this is very important, and I totally leave to my Chinese colleagues the determination of Chinese policy, but I hope they listen to this, in which the Soviet Union drastically changed position based on a change in its interests. At the first conference of the Law of the Sea, the Soviet Union thought of itself as a land power, and it therefore pushed for the maximum possible limit for coastal state sovereignty, which was 12 miles. By the time of the second conference, which, by the way, was a result of Soviet diplomatic efforts, not the result of a speech by a Maltese ambassador, as is ordinarily reported, Soviet Union in 1967 sent a diplomatic note to 60 countries saying, what about a new conference on the law of the sea? And by then, the Soviet Union is supporting the same 12-mile limit, but for completely opposite reasons, and that is it's the narrowest possible limit on which you could achieve consensus. What happened in the interim is the Soviet Union became aware of the fact that it was now a global maritime power, not just in a military sense, but in terms of merchant ships, fishing interests, and so on and so forth. Legal positions, by the way, always lag behind, but finally the legal positions caught up with the interests. And interestingly, in my view, that shift in Soviet perceptions meant that you would not have the kind of Cold War divisions that you had previously had, and one goes ahead with a conference. The conference took a long time. As a formal matter, it convened in 74 and ended in 82, and then you needed an implementing agreement, which itself didn't appear until many years later. In fact, preparations started before. Young people who think they can replicate this, right, in 2 months in some pleasant venue are I think, mistaken. And the end result in negotiating by consensus rules were, of course, demanded by the United States, is the Convention on the Law of the Sea, which at the very end, the United States shifted position, demanded a record vote, and voted no. They one of 4 states to vote no. The convention then began to be ratified. They had to fix the part on deep seabed mining, which is not directly relevant to what we're talking about here. Entered into force, and as I've indicated before, is now in force for the overwhelming majority of states in the world. Someone arguing that those rules are not rules of customary international law would have an uphill battle. In any event, South China Sea, as has been pointed out, you have parties to the convention. The system established is a complex one, and you all have these maps which demonstrate some of the areas. I will jump beyond so-called internal waters, although one sometimes wonders whether what's shown as internal waters in South China Sea can properly be regarded as such, but we'll just put that aside. Following a baseline which runs along the coast, you're then entitled to a territorial sea where you are sovereign. which has a limit of 12 nautical miles. Can't go beyond. What exists beyond is a compromise that is based between coastal interests and maritime interests, which is based not on the location of a line, but on the nature of the regime. So that some powers vest in the coastal nation, some freedoms of the seas are preserved. And that exists in two zones that begin at 12 miles that are relevant here. One, the exclusive economic zone. Two, the continental shelf on the seabed. Both of those extend out to 200 miles from the coastal baseline, so roughly 188 miles from the 12-mile limit. Natural resources in that area are effectively are under the control of the coastal state, which has sovereign rights over their use. At the same time, the freedoms of navigation and communication are protected in the exclusive economic zone, as on the high seas. And the question, in answer to Professor Cohen's question earlier, it's not just navigation, overflight, and submarine cables and pipelines, but other internationally lawful uses of the sea related to these freedoms, which everyone at the conference understood was addressing military activities. They just didn't want to say so. But that was clearly, quite clearly, what was understood by, by that text. So that for navigation and communications purposes, the economic zone is assimilated to high seas. For resource purposes, it's similar to, although not identical to, the territorial sea in the sense that it's under discretionary coastal state control. The reason that you have both an exclusive economic zone and continental shelf is historical accident. And that is that the continental shelf doctrine was accepted in international law several decades before the idea of an economic zone in the water column also came to be accepted, and so you wound up with both. Beyond 200 miles, the coastal state is also entitled to sovereign rights with respect to the resources of the seabed if what in geology is called the continental margin extends beyond that limit. And it is that area that, interestingly enough, becomes one of the areas that occasions the emergence into the spotlight of some of the disputes that are being discussed here. Both Vietnam and Malaysia, as well as other states, believe that their entitlement to a continental margin extends beyond 200 miles. In one area, that of Malaysia and Vietnam would overlap, coming from the opposite coasts. These entitlements overlap. The coastal state that believes it has a continental margin beyond 200 miles is required. This is not an option. It is required by the convention by a certain date to submit to an international commission set up by the convention its proposed limits. The commission then reviews them. It then makes recommendations. This is an interesting system. The coastal state is not required to accept the recommendations, but if it does, the limits that it establishes are, quote, final and binding. Now, what Malaysia and Vietnam did in a particular area has been done by other states, and that is because they had not, they're going to do joint development, but in any event, they had not resolved the boundary between them. They were preferring a different approach, went in and made a joint submission. And what happened is that China at that point, which did indeed have a right to comment, submitted a comment asking the commission not to consider these submissions because there was a dispute as to jurisdiction and sovereignty in that area. China's submission contained a map showing by now what you have become familiar with, the 9-dash line, which is shown in red on the maps that were distributed here. And that 9-dash line and China's map provoked, let us say, firm responses from a number of states in the region, including Vietnam and the Philippines and Indonesia. and others. Now, you've heard here, and I want to stress, that the entire Convention on the Law of the Sea, indeed the entire Law of the Sea, is proceeded on the assumption that derogations from the freedom of the high seas, that is the territorial sea, economic zone, continental shelf, require land territory. And if it's argued the principle is the land dominates the sea. Now, you also saw the calculation that if you go to very, very broad limits of jurisdiction, then tiny islands could have very, very substantial amounts of jurisdiction. And because of that, a provision appeared in the convention that said that in the case of rocks, which are islands, they are islands because they're above water at high tide, which is how islands are defined. But if they are rocks which cannot sustain human habitation or economic life of their own, then they don't get nothing. They get a territorial sea, but they do not get an exclusive economic zone or continental shelf. And it is that legal background that, as has been already pointed out, provides the basis for the multifaceted set of disputes in the South China Sea, about which Professor Beckman will talk in general, but let me rehearse them. First, if the land dominates the sea, and you have a dispute with respect to sovereignty over the land, which can include dispute of sovereignty over the island, then you automatically have a dispute over who's entitled to a territorial sea, economic zone, continental shelf. Second, even if there weren't a dispute as to the land, if there is a question as to whether that island is a rock or not, that will be an exceedingly important question. If it is not a rock that can't sustain human habitation or economic life of its own, then it gets not just a 12-mile territorial sea, but pi r squared, a 200-mile exclusive economic zone and a continental shelf. If it is a rock, it gets only a 12-mile territorial sea. Finally, and this is yet another complexity, if the entitlements of two states overlap, for example, Vietnam and Malaysia, as you saw in that area, the two states can agree on joint development of the overlapping area if they wish, but if not, there are rules of international law governing the delimitation of the overlapping entitlements. So that even if a small island generated a 200-mile exclusive economic zone, there would still be a question of delimitation if that 200-mile zone itself overlapped the 200-mile zone coming from other land territory. The delimitation cases are many. There have been many cases decided by the International Court of Justice. The Law of the Sea Tribunal has just decided one, arbitral panels, and they are complex. In recent years, there have been 3 cases that have dealt in some detail with the question of the limitation of areas where there's a small island in the area. Those are the Black Sea and Nicaragua-Colombia decisions of the International Court of Justice and the Bay of Bengal decision of the Law of the Sea Tribunal. One, finally, and then I will turn this over to Professor Beckman, one of the most extraordinary contributions of the Law of the Sea Convention to the rule of law in international affairs, if you believe in the rule of law in international affairs, I have a feeling that there isn't unanimous agreement with Professor Cohen here on that issue, but I'm certainly in agreement with him, is that it contains a system of compulsory third-party settlement of disputes, consent in advance to go to arbitration or adjudication if the dispute cannot be settled by other means. Now, as has been pointed out to you in previous panels, there are pre-qualifications, that is, you have not been able to settle the dispute by other means, and there are then exceptions with respect to certain kinds of disputes. I do want to point out that the provisions on dispute settlement, their application in the situation as described already at this conference, is evident from the text itself. First, the dispute had to be submitted to arbitration because China and the Philippines, if you were going to submit it at all, it couldn't go to the International Court of Justice or to the Law of the Sea Tribunal, because under the convention, if the states haven't filed declarations choosing those and haven't both done so, it automatically goes to arbitration under Annex 7 of the convention. And under Annex 7, the system as it's supposed to work ordinarily is that each party appoints one arbitrator, then the two parties try to agree on the remaining three. It's a panel of 5. But the convention is quite specific. If one state doesn't appoint its own arbitrator, then the other party may request the president of the Law of the Sea Tribunal to appoint that arbitrator. Similarly, if the two states cannot agree on the remaining 3, then either party may request the president of the Law of the Sea Tribunal to appoint the remaining 3. And then what you get is a panel of 5 arbitrators. I also want to point out that the convention expressly contemplates the possibility that one of the parties will not appear. In Article 9 of Annex 7, for those of you who have this, it's on the last page. If one of the parties to the dispute does not appear before the arbitral tribunal or fails to defend its case, the other party may request the tribunal to continue the proceedings and to make its award. Absence of a party or failure of a party to defend its case shall not constitute a bar to the proceedings. Before making its award, the arbitral tribunal must satisfy itself not only that it has jurisdiction over the dispute, but also that the claim is well-founded in fact and in law. Unlike American procedure, where you have something called a default judgment, there is no default judgment here. If the one party doesn't appear, the other party will have to satisfy the tribunal that there is jurisdiction and will have to satisfy the tribunal on the merits. And finally, in Article 11 of the Annex, the award shall be final and without appeal unless the parties otherwise agree. It shall be complied with by the parties to dispute. So I just want you to know that the text itself addresses one of the eventualities that has been discussed here. One final word. The Law of the Sea has an exceedingly long history. It can in fact be traced back, and frequently is traced back, even in Europe, much, much before the Westphalian, the emergence of the Westphalian system of states. There have been empires that have made significant contributions to human history in many parts of the world, and I think we have to bear in mind that it is against that background that this effort was made to agree on a universal basis on what the rules of the Law of the Sea are. A quick word on the question of historic rights or title, and very fast. The convention in its substantive text does not talk about this issue very much, except in one place in a truly peculiar provision, which talks about so-called historic bays. It's very rare for a legal text to talk about so-called something. And those would be relatively small areas off the coast, which didn't quite satisfy the requirements for a bay. Since we're in New York, I'll give you an example, which I had worked on many years ago, which is the example of Long Island Sound, which is regarded by the United States, I think properly so, as a bay, even though, as you all know, you can connect into the East River and the Hudson River and so on and so forth, but it's clearly like a bay. But these are small areas that look like a bay. That's pretty much it on the substantive provisions. Dispute settlement provisions contain this reference to historic bays and titles, and a lot's going to be said about this. I do want to tell you what the history was. Whether lawyers can resort to history, certainly political scientists can do so. We have these dispute settlement provisions due in large measure to the extraordinary efforts by the head of the Australian and the head of the El Salvador delegations, Ralph Harry of Australia and Ambassador Galindo Pol of El Salvador. And they produced quite an extraordinary feat in getting the Latin American states and other developing countries to support compulsory settlement. This was not normal at that time, and you could argue it still isn't normal, but it was certainly not normal at that time. Ambassador Galindo Pol had a problem. His problem was the Gulf of Fonseca. His government was not about to agree to compulsory settlement of the delimitation dispute with Honduras and Nicaragua and the historic claims to the Gulf of Fonseca, which is clearly just like a bay. It's a very small area. And in order to achieve consensus, Ambassador Galindo Pol wrote this language, and it was put into the text. And there it stands. Clearly, it's now everybody else's job to try and figure out what it means, but I did want to at least add that little piece of history. There was no indication, certainly at the time, that you could simply eliminate the dispute settlement obligations under the convention by making a historic claim of some sort, which would be the effect. But that's where matters stand, and for those of you who are experts, clearly this talk was not designed for you, but there are a fair number of people in the room who I thought might at least welcome a little bit of a general description of the convention, and I hope it did help Professor Beckman get into the details here.
Thank you very much. I'm going to use slides since it's 2:30 in the morning Singapore time. I will stay awake if I can stand up. Is this working? Yep. First, I'd like to thank the organizers for inviting me and giving me the opportunity, and for Bernie for doing a large part of my job. I hope that I can relate what he has said to the complexities of the geography of the South China Sea. Okay, radios are off. Background to the case. There are territorial sovereignty disputes which are not governed by the Law of the Sea Convention. And in the South China Sea, we have a dispute over the Paracel Islands, which are claimed by China, Taiwan, and by Vietnam, and are occupied by China. We have Scarborough Shoal, which is not part of the Spratlys. It's a separate island. It's actually the largest underwater reef in the South China Sea, claimed by China, Taiwan, and the Philippines, and as of the last few months, effectively occupied by China. And then there's the Spratly Islands, which are claimed in whole or in part by China, Taiwan, Vietnam, Philippines, Malaysia, and Brunei. Now, sovereignty and maritime claims. The bordering states, Vietnam, Philippines, Malaysia, Brunei, in fact, China to the north also, claim a 200-mile economic zone from their baselines along their coast, or in the case of archipelago, from their archipelagic baselines, the case of the Philippines. They've also claimed or indicated with preliminary information that they will claim an extended continental shelf beyond the limits of their 200-mile economic zone. We can see that in a moment on the map. What is significant in the claims that have been clarified since 2009 because of the May 7th or the May deadline of 2009, this is a watershed in the disputes because the states bordering the South China Sea in effect clarified their claims. In order to claim an extended shelf beyond 200, you had to tell the world where your 200 limit was. And this was the result of the series of disputes which have arisen since then. But what is significant is that Vietnam and the Philippines and Malaysia have all clarified their 200-mile claims, but they've made their claims only from the mainland land territory or main archipelago. They have not indicated that they are going to claim an economic zone from any of the offshore islands. And to obtain access to the resources then, as we'll see here, we'll bring this map to life a little bit, I hope, is this is what's happened. Vietnam has made their 200-mile claim here with Malaysia on this side. Malaysia's clarified its 200-mile claim here, and the extended shelf claim of the two countries is this orange area. Vietnam's made a separate, this again, their 200-mile, they've made a separate extended shelf claim out in this area, and we expect that the Philippines has given notice they will probably make an extended shelf claim here. So we have 200-mile claim here with this little kite-like shape in the middle would be high seas in the water and possibly extended shelf from in terms of the seabed. When these are made from the land territory, well, the gas deposits and oil deposits happen to be over here and over here. So guess what China gets under this procedure? Nothing, because China's way up here. So the economic zone claims that were clarified in 2009 give the Southeast Asian claimants almost all the gas and oil and a large portion of the fish. Now, Scarborough Shoals over here, that's claimed only by China, Philippines, and Taiwan. Paracels is claimed by, that's a two-party dispute in effect between China and Vietnam. It's the Spratlys which are claimed in whole or in part by Malaysia, Vietnam, Philippines, Taiwan. And Brunei got out a ruler at some point and drew a 200-mile claim out. And there's one reef here which is not clear whether they're claiming that it's above water or not. So that's the significance of it. It put China in a dilemma, because for China to have access to the resources, they would either have to claim a zone, economic zone around some of the larger islands. These blue shaded areas would give 12 miles around each of them, or they would have to come with, and when they objected to the joint submission of Vietnam and Malaysia, they attached a map, and the map are these 9 dashed lines, those red lines. China's never claimed sovereignty over the water. They've said sovereignty over the islands and their adjacent waters, but rights beyond that. So that should, now, the features in the Spratlys, which is where all the confusion is, there's more than 100 geographic features. Less than 40 meet the definition of island. An island is a naturally formed area of land above water, surrounded by and above water at high tide. Not through artificial reclamation, but naturally formed. And above water at high tide, not low tide. Only 10 or 13 of our study at my center would probably be large enough to pass the straight face test of being an island. The dry land area of the 13 largest is about less than 2 square kilometers. My rough estimation, put all the islands together in half a Central Park. That's what you're talking about over a very large ocean area. The largest is actually complicates matter further, occupied by Ituava. That's the island the Japanese used to invade the Philippines during World War II. That was occupied and has been occupied by Taiwan. It's the only one with fresh water. It's 400 meters by 1,400 meters. We're not talking about huge islands here. We're not talking about Long Island. Many of the occupied features are actually low tide elevations. They're below water at high tide. And they have structures built on them. these are the 10 largest. And notice there, this is the Philippines. This is their archipelagic baseline. This is their 200-mile limit or proposed limit. This is the 200-mile limit of the Malaysia. This is the 200-mile limit of Philippines. The KIG claim, the Kalialan Island Group or Freedom Land of, this is the box. Philippines does not claim the water, but the islands within this box it claims. All the larger features are in this right area right here. And one over here, Spratly Island, occupied by Vietnam, another one down here. But all of the larger features are in a relatively small area. So if just one or two of those are large enough to, in principle, be entitled to an economic zone, you're going to have an overlap of some kind. That's Ituaba. That's what we're talking about, 400 meters by 1,400 meters. There's an airstrip on it. They're going to try to extend the airstrip. I almost got a trip last year on the C-130 can land there, but the weather didn't agree with us. This is another island closest to Reed Island. Reed Bank is where the Philippines wants to drill for oil. Now, this is apparently brackish water, according to my satellite friends. There's some buildings here. There's a little road. There's a wall of here to keep the erosion out. It's 390 meters by 290 meters. And that's the issue. Will it sustain human habitation? If we drop 20 of you there with a month's supply of food and come back in 2 months, how are you going to be doing? Come back in 6 months, how are you going to be doing? What do we mean by sustain? This is what the court might have to deal with. Of the occupied features, remember there's less than 40 are islands, but there's more than that are occupied. Vietnam occupies the largest number. This is one study. I can't guarantee it's accurate. 25, but 5 of the largest are occupied by Vietnam, 8 by the Philippines, including 5 of the largest, 7 by China, which are at issue in the case, 3 by Malaysia, and the largest by Taiwan. Where are they here? The green ones are occupied by Philippines, the purple ones by Vietnam, the red ones here are occupied by China, yellow ones down here by Malaysia, and one slightly different color here is this dark blue is Ituaba. That's the one occupied by Taiwan. Now, some of these features are obviously not islands. They've occupied things which are below water at high tide. Now, the legal disputes. Different categories. The territorial sovereignty disputes. Who owns which island? Law of the sea has nothing to say, cannot be resolved. You can either set it aside, as Deng Xiaoping suggested, or you can take it to a tribunal, or you can continue to repeat that we have indisputable sovereignty and we don't recognize anybody else's. But the other 4 countries are going to continue to repeat that they have indisputable sovereignty. And this case will not resolve that issue in any way. UNCLOS disputes are in the interpretation or application of the provisions of the convention. Maritime boundary delimitation, when there are overlapping claims, are excluded by China's declaration. The 9-line case, because the whole issue from the Philippines and Vietnam perspective is the land dominates the sea. If China is going to make any claims to maritime space, to resources in the water, it must be from land. It must be from islands. Islands must be naturally formed areas above water at high tide. And therefore, claiming some vague idea from historic rights based on a map is simply not consistent with the Law of the Sea Convention. The Law of the Sea Convention governs access to resources in maritime space. It governs historic fishing rights. 2 countries argued for historic fishing rights to be recognized in economic zone, the Soviet Union and Japan. May have been others. But it was rejected by the third world countries with support of China because they said in the economic zone, the coastal state must get sovereign rights. And if they give any access to a surplus they cannot catch to countries whose nationals have habitually fished in those waters, it's up to them. In other words, they're the sovereign. They control who fishes in their economic zone. So the fact that Chinese fishermen have fished there for centuries, the law of the sea changed all that, and China accepted that when it ratified the convention. That's the position of the Southeast Asian claimants. Rocks and islands, very important, because as we've shown, the features are so small, it is very significant whether any of them would be large enough to get a economic zone. And a lot of them are low tide elevations are submerged. The significance there is that low tide elevation is a naturally formed area of land which is below water at high tide and above at low tide, which means it gets no territorial sea, no economic zone, no continental shelf. A little more complicated in terms of base points, we'll leave it there. And Philippines is raising these issues in their case, and including the last one, is it saying China is interfering in our fishing and in our oil exploration in our economic zone in areas within a 9-dash line, because we don't recognize the legitimacy of the 9-dash line because maritime claims must be made from land. So that, simply stated, is what the case is all about. China's position, as it's evolved over the last 3 years, is they continue to say they have indisputable sovereignty over the islands and their adjacent waters. Most of us assume that means 12-mile territorial sea. They have sovereign rights and jurisdiction in the EEZ and continental shelf measured from the islands. That's, again, consistent. That's the language of UNCLOS, assuming there are some islands that they claim which are entitled to an economic zone. And they have the third one, which is challenged by the Southeast Asians. They have historic rights and jurisdiction over the natural resources somehow within the 9-dash line. The Philippines' position there is land dominates the sea, and you must claim from land territory, and claims to, based on history, if on a line from a map, are not recognized. That's the official map which China attached to their UN note, and it shows the lines, and the lines come right up to the coast of the Philippines. Actually, in this area, they even intersect with the economic zone and continental shelf claim of Indonesia, and they're right up along the Vietnamese coast. So if somehow historic rights of China exist in this entire area, then it's directly contrary to the law of the sea. But they seem to, in their statements, this is in response to a statement of a note verbal of the Philippines, they have brought into their language increasingly, at one hand, there's language consistent with UNCLOS, and then they'll throw in something related rights and jurisdiction supported by abundant historical and legal evidence. And there's further statements, MOFA spokesman in 15 September, the last line as well. This was in response to the fact that they'd issued oil blocks in areas right off the coast of Vietnam, saying the UNCLOS does not restrain or deny a country's historic rights, basically. And so it seems, to an international lawyer's perspective, directly contrary to the convention. Disputes on islands and rocks, the Philippines is challenging only the features occupied by China. They say Scarborough Shoal and 3 other reefs they admit are above water at high tide, or there's small protrusions in the reef that are naturally above water at high tide. But they say these islands are so small that they would be entitled only to a 12-mile territorial sea, and therefore if those rocks are within our economic zone, then only the 12 miles around them would be in dispute. Everything else is our economic zone, and you're interfering in our rights if you go beyond that. And they argue China's unlawfully exploiting resources beyond the 12. That's the language, and this is the infamously, we can blame people like Bernie for agreeing to language like this. Right? This was what we call diplomats at their best. let's use language that's so vague that nobody knows what it means, and therefore we can all reach agreement on it. Right? It's rocks which cannot sustain human habitation or economic life of their own shall have. And they're leaving it to the courts, but even the International Court of Justice has refused to rule on this issue. They've dealt with it as a matter of delimitation. But in this case, the Philippines is raising exactly because they're saying the 4 islands in dispute that are occupied by China are not entitled to an economic zone because they fall directly within 121.3. These are the islands, these are the features in dispute. Those in yellow are low tide elevations, according to the Philippines. And these 3 islands, notice that 3 of them are within their 200-mile economic zone, and 2 of the low tide elevations and 2 of the islands are actually outside their economic zone. And they're saying these are, if they're the yellow ones, they're not even islands, and therefore you have no economic zone or even a territorial sea around them. But if they're islands, you only get 12 miles, which are these, this is the U.S. State Department map. You'd get the 12-mile, the yellow circle. That's it. The rest would be, of this area, would be economic zone of Philippines, which they have no right to interfere with. Scarborough Shoal is up north of this area, considerably off by itself. Very large reef. Now, is this a rock which can sustain human habitation? I think no one would have any doubt that if the other rocks on Scarborough Shoal are this size, there isn't any way that this would be entitled to more than a 12-mile territorial sea. This is one of the other reefs that's above water. There are a couple of features here. Before this massive structure was built, something here must have been naturally above water, according to the old British hydrographic charts. It's located here. But what you have now is an island with a nice structure built on it, occupied by China, which the Philippines would say, we admit it's an island, but you only get 12 miles around it. The rest would be our economic zone. Some of them are submerged. There's 4 reefs occupied by China, which Philippines is calling low tide elevations because they're not above water at high tide. They would get no zones of their own. This is a low tide elevation provision. A naturally formed area of land surrounded by and above water at low tide, but submerged at high tide, therefore not an island. They get no territorial sea of their own. If artificial islands and structures, again, no territorial sea of their own. There's a couple of them. There's the Mischief Reef, which China took over in the mid-90s. They've built a nice structure on it. Under the law of the sea, the state with jurisdiction is a state on whose continental shelf it lies. So the net result of the case could be if the court held that Mischief Reef lies on the continental shelf of the Philippines, Philippines can thank China for building them a nice structure. Procedural issues, Bernie's covered most of this. General rule is any dispute on interpretation, the exceptions 298. That's the exception. The process was initiated on 22nd January. The train left the station, right? The Philippines has expressly, in their statement of claim, said we are not raising issues of who owns which island. We're not raising territorial sovereignty disputes. We're not asking you to draw maritime boundaries, settle areas of overlapping claim. We're focusing on issues that do not fall within the exclusion. That's the timeline. I expect that by now, since the 30 days has passed, the Philippines has officially requested the president of the International Tribunal to appoint one arbitrator for China. Beginning on 23 March, if the deadline for appointment of the remaining 3 among the parties will stand, and then Philippines can now, in this period, they have 2 weeks to request the president to appoint the remaining 3. So there will be a tribunal. As Bernie said, absence to appear doesn't affect the party Other party, Philippines, can request the tribunal to continue in the absence of China and issue an award. The award will be final. Case can be settled at any time, right up to the time the arbitral award is issued. I would assume China's giving some thought to that. If they can get the Philippines to agree, the case could be dropped. But the question is whether that's possible and what's happening, we don't know. Conclusions? The case presents a challenge to the dispute settlement system of UNCLOS, particularly since one of the states is not participating. It will not resolve the underlying disputes as to who has sovereignty. That issue remains. The court will have the tribunal can say nothing about that. It will not resolve any maritime boundary issues, but it can have a significant effect on clarifying the legal issues, because if it gives some clarity to rocks and islands and to what maritime zones can be claimed from which features, and the parties comply, then it will have a lot more clarity, and we could move to that point, which all of us assume is the only long-term solution, is setting aside the sovereignty disputes and attempting to find in areas where you can jointly develop the resources. That's impossible now because China says, yeah, there is the area. Everywhere within the 9-dash line, 50 miles off your coast, we get to share. And for some reason, the Filipinos and Vietnamese don't think that's fair, because they also don't think it's consistent with international law. So that's where we are. Thank you very much. I think that's it.
We have the last speaker.
Yes, I'll try to make it very short. More time for questions and answers. Anyway, I'd like to thank Professor Oxman and Professor Beckman for that wonderful exposition on the legal aspects of the case. And that would free me from a few of my notes here, so I can focus on the political and governance side of it. We always define politics as the art of the possible. So I would like to be optimistic about generally sometimes the negative feeling about the effect of filing a case and whether it can result in resolution of the problem, or at least managing the issues. I would like to remain optimistic, and so I will focus on the political. I'll be sharing with you some political perspectives from the Philippine side. Despite filing of the arbitration case, despite American colonial experience, the Philippines is not always a litigious country. As I was preparing for this paper, a group of followers of the Sultanate of Sulu just went back to their homeland in Sabah and forced another issue with Malaysia, which is our neighbor, and don't expect the Philippines to file any case with either the ICJ or the UNCLOS about it. It's one of the major issues, and the Philippine government is doing its very best to settle the problem together with the Malaysian government, to the extent that it's being accused by Filipinos of speaking more for Malaysia than for our citizens. But this has underlying reasons. Malaysia was the sponsor for the framework agreement recently signed with the Philippine government and the Moro Islamic Liberation Front. And so it played a very important role because there's a history to that's beyond the scope. I'm just citing it as a first. So I would like to start by viewing the problem from the practical perspective of domestic politics and governance, which I believe is the main driver of policy, particularly in the dispute, and the critical crucible of national interest calculations. And I would like to come out at the end with a general suggestion on the way forward. International law is only as strong as the institution that undergirds it, and these institutions are always political in nature. So I believe there is hope, still space for, despite sometimes the negative feeling about this, there's still space for adroit diplomacy and leadership in Asia. And despite sometimes the failure of dialogue, I think we need more dialogues. There are three things about the arbitration from the perspective of the Philippine political leadership. Number one, there is nothing deterministic about it. There's nothing predetermined, nothing inevitable about the decision to go the way of arbitration. As a matter of fact, the President was widely reported to be very hesitant in filing that arbitration case last January 22. But he was prevailed upon by the fact on the ground that the Philippines has lost all other options of preventing further Chinese exercise of jurisdiction and further occupation of areas which are disputed territories, and it was beginning to be politically difficult to handle. As a matter of fact, I would go as far as some observers would say that the decision, and I'm not with the government, so I can say this, there was an element of duress when the decision was finally made to go ahead with the arbitration case. And this has been a result of extreme frustration with the 9-dash line, with Chinese practices, and the past dealings, bilateral dealings with China. And equally so, by the extreme frustration of the Philippines' lack of capability to counteract it in any effective way. I will be discussing further on the capacity later on. So these are the underlying reasons. The other one is that the decision is popular in the Philippines. The worst time to make a decision like this is during an election time. We are in the midst of a midterm election, and so far, no opposition figure has made this a major issue against the President. As a matter of fact, if you make this a major issue, I would say that you would look unpatriotic at this time when everyone is trying to play to the galleries. And that's another of my observations down the line. So the grounds, of course, officially, it's been there already. It has been mentioned that the bilateral negotiations has been going on for the last 17 years since the 1995 mischief incident. Nothing much has happened. So the obligation to confer immediately has been satisfied, and so there was the filing of the case. Another one, of course, is the frustration with the Code of Conduct, the progress of the Code of Conduct. As you very well know, the Philippines pushed hard for this, together with ASEAN, of course, but the Philippines really pushed hard for a Code of Conduct arising from the Treaty of Amity and Cooperation in the 70s, and then the 1992 Asian Declaration, and then the 2002 DOC, or Declaration of Conduct. So it wanted to have a Code of Conduct precisely because it does not expect this to be resolved soon, but it just wanted to ensure that it doesn't go out of hand. So it's not to resolve the issue, but to manage the issue. And that's the most important reminder about the Code of Conduct. And it even suggested the idea of a zone of peace, freedom, and friendship and cooperation in that area, but it was easily shut down. Right now, ASEAN has its own version of DOC after discussing the Philippine version last year. And it's much watered down from the Philippine version, but I just tell you that the presidential vision of that zone of peace, friendship, and cooperation was that what is yours, what is disputed, or what is mine, what is disputed, we can go for joint cooperation. Of course, this goes straight against the wall of the 9-dash line and the status quo concept, which was just recently explained today. So there was really no hope for that particular kind of concept. And so the practical ground really was that the President had to make a decision, and there was just no other option left for that moment, particularly at this moment, but to file arbitration. But this doesn't lessen, of course, the fact that the Philippines has always been consistent in trying to push for a rules-based approach, and it has been discussed earlier, on particularly political, diplomatic, and legal tracks. And the legal arbitration case is just part of the legal track. The political track, as I've mentioned already, previous efforts has always been focused on ASEAN, on the centrality of ASEAN. And I have mentioned the 1992 ASEAN Declaration, the 2002 Declaration, or the DOC, and then the COC effort today. So when they filed this case, there was no illusion at all that the problem could be resolved, but there was a hope at that time that it can moderate perhaps further exercise of jurisdiction by China, which is a neutral word. I mean, the term in the Philippines is interference in our exercise of jurisdiction. So the accepted risk considered by the Philippine decision was, as already mentioned, was the constitution itself of the tribunal. If the China does not accept it, the Chinese acceptance, the Chinese decision was very well foreseen but when the Philippines decided to go for arbitration. So the constitution of the tribunal is very important because it will determine later on the credibility of the tribunal. We know very well that the president of ITLUS is Yanai from Japan, and he's a long-term time diplomat. We don't know how he will exercise, because under the rules he can abstain and let the next senior member of the tribunal pick up the case under the UNCLOS to decide the other members, but he has the chance to decide the majority of the members of the tribunal. So this is very critical as far as the Philippines is concerned. The other one is the jurisdiction of the tribunal, but I will not discuss it anymore, so I can save time. The Philippine position tried as much as possible to go beyond the Chinese reservations. And the problem really right now, as far as international law is concerned, is that whether the tribunal, once it is constituted, will adopt a formalist, strict constructionist view of its own jurisdiction, or a more activist, liberal view as a great opportunity for international law to exert its presence in the dispute. And this is the first time in this particular dispute that we bring in the ITLUS procedures and the UNCLOS in general. So these are known risks. Of course, the judgment today, the final, it has been repeated that in spite of default, there still has to be factual and legal ground to base the decision on. This is for credibility and added moral authority. But in the end, it is still, and I believe it is still a very good move forward as far as the development of a rules-based regime in the South China Sea, which is sorely lacking today, and is one of the major causes of some of the deadlocks that we're experiencing. It does not settle the issue of sovereignty, and that's fairly well established, so it does not really end the crisis, but it is a move forward. So, as far as ASEAN is concerned, the Philippines definitely expected support from ASEAN. There are certain things about ASEAN. There are risks involved in holding a big neighbor to court. The ASEAN is free of this risk. I mean, the Philippines has done it for them, especially the other claimants. The ASEAN as a whole have always criticized the 9-dash line, but this time this 9-dash line can be scrutinized without inviting indirect Chinese displeasure or retribution. Other claimants, if they get a favorable discussion, they can add to their arguments, but if it's not favorable, then again, it only binds the parties. Only the Philippines and China will be bound. Although, of course, it can exert influence. So, and second, as far as ASEAN is concerned, by having a live case going on, and introducing this concept of arbitration right now, it is hoped that it will result in a moderating influence as far as the practice, the very assertive and practice of China along the 9-dash line, which is the source of so many complaints, as far as the other claimants are concerned. We still believe that China is sensitive to international opinion, and even if we say that it will not participate or even recognize that thing, and this is theoretical, it cannot ignore international opinion forever. At the end of the day, only the Philippines face the risk, especially the political fallout in case you get an unfavorable decision or a decision that is favorable but cannot be enforced. This is going to be politically, the political fallout is going to be incalculable as far as Philippine domestic politics are concerned. But the larger risk really is, the trial, what is on trial here is not so much the claim anymore, but the role of international law and the institution that undergirds international law. And that has already been well explained here. There was the Philippines were debating earlier, and I was privy to some of those who participated in that, either directly or indirectly. They're saying that it's very hard to get enforcement if China will simply not cooperate, even if we win this case. So if you're going to have a moral victory, just a moral victory, because so far, as far as this case is concerned, it is unprecedented. But then there is a major problem with moral victory, because a moral victory is a self-defeating concept. I mean, there's a victory, but it's only moral. It can even be a setback to international law, the development of a rules-based regime. And these are some of the larger risks that has far-reaching implications as far as the development of international law is concerned. So the international law itself would be on trial. Now, let me just mention to you something sensitive, but I think has to be discussed. One of the things, it is not part of the political, legal, and diplomatic approach to the problem, but definitely the Philippines today is in a transition as far as defense capability building is in a transition from internal security focus to the focus on territorial defense. This is not directed against China, but it cannot be denied as well that the lack of Philippine capacity, I'm talking about capacity, has been made more salient and urgent because of this particular Scarborough Shoal incident last year. Let me just mention, the Philippines is probably, it's the weakest among all the claimants in the South China Sea militarily in terms of capability to project its presence or defend itself. And there are several reasons for this. And I just make it very, very, very short summary. Number one, historically, we have always been over-dependent on the U.S. for a shield against external threats. We have before the bases, Subic and Clark Air Base. Number two is that we have always focused for the last 40 years on internal security. We have Moro successionists in the south, and then overall, in the entire country, we have a Maoist-inspired communist insurgency. So all the resources of the military, limited resources, have been focused on this. The other one is there is a lack of priority on military spending in the Philippines because for a long time, military spending did not have a political constituency. The holder of the purse in the Philippines is Congress. Congress has basically been very parochial. As a matter of fact, during the 1997 Congress, the Armed Forces in the Philippines Modernization Law was suspended because of that crisis, where the peso plunged so precipitously low that we cannot afford to continue with that thing. So, and then number four, very important, the Philippines has never felt any external threat before. We have always felt as a people safe in our waters. We never shared any land borders. So part of our psychology is there's no, except of course during World War II, but very few of us remember that anymore. I mean, Ito Aba, the Japanese used the Spratlys to invade the Philippines. And that was why the reason why in 1947 we demanded from the Allied powers that the Ito Aba, the Spratlys be surrendered to the Philippines because it was used as a launching pad for the invasion. And we even sent a notice to Taiwan that you don't need that garrison in Ito Aba, there's no more threat. But I will not include that anymore in the report, in my report now. So, okay. So this has changed. Defense policy is beginning to become good politics in the Philippines today. And in the last year, the AFP modernization law was expired. It was extended. The Philippines signed the status of visiting force agreement with Australia. It has opened up new defense relations with Japan, which is on an offensive right now with the election of the new nationalist prime minister. And definitely, of course, we're not just basing on the United States is the only one that we have an actual security arrangement. I mean, we're talking about the 1951 MDT, Mutual Defense Treaty. But as far as procurement is concerned, we're casting a wider net, including Russia. But definitely, the alarming thing here is that it is not to anyone's interest, especially the Philippines, to be engaged in any unusual escalation of defense spending or what we call an arms race. It is not good for it. The economy in the region has been going on because of peace and stability, and it is not to our interest that we shift this. So just this defense spending is based on, now this defense posture is what we call the minimum credible defense posture. Defense, minimum credible. You know very well that one of the reasons why the Philippine Navy ship was used to arrest the Chinese vessel for poaching on Philippine waters, they were endangered species there, and there were protected species as well, live corals, baby sharks, was that we don't have a very sophisticated Coast Guard. And so a Navy ship was deputized to make that particular interdiction. It's so limited. So the ship from external defense has been already laid down in the government's national security goal 2010-2016. So there is some barriers, of course. Although the Philippines is saying that arbitration is a friendly act, it is apparently not seen as a friendly act on China. But I like to repeat that, and I agree with our defense ministry, that we have a stable relationship, we have a very productive relationship with China, except for this particular issue. But I mean, our response has definitely not been. If you remember, during the start of the Scarborough Shoal, China immediately came out with a travel advisory on visits to the Philippines, and China is a large market for Philippine tourism. The other one is that suddenly the Philippine bananas, a major export to China, has been subject to what exporters call impossibly stringent regulations. Suddenly, after the, we're the number 2 exporters of Cavendish bananas. That's why you call us, we're not a banana republic. So, another one is the rise of nationalism. I'm glad that some posters some posters were shown earlier. But nationalism is not exactly a bad thing in the Philippines, coming out of its colonial past with the United States and a longer one with Spain. And nationalism is a positive force, but perhaps we should define it as more like a chauvinistic nationalism, a bellicose type of thing that believes in your superiority, that you're always right. And I feel that this is the kind of nationalism that is the problem, because I still believe that nationalism is a positive force, especially in creating the Filipino identity. So there is the rise of nationalism, and if you look at the social media, the remarks from people are really so low. I don't even care to repeat them now, like, no, Vietnamese, Philippines, or dog. And the Philippines is equally guilty of those things. So the rise of nationalism is creating an atmosphere that is very, very difficult for government. It's constraining government space for maneuver, and everyone is playing to the gallery, especially in the Philippines, where you have only 3-year election, and the election cycle is only 3 years. So it's very hard to come out with, and the first to come out with agreement, the first victim here is trust. And this lack of trust has been worsened by bunglings as well. If you will remember, in 2005, there was a joint marine seismic undertaking with the Philippines, China, and Vietnam, and it was fitted to be an example of joint cooperation under the dock. The problem was, it was exposed, for example, the President Arroyo was accused of selling Philippine sovereignty, because it included some parts which were not even disputed. The President was accused of selling our sovereignty for some Chinese loans or some Chinese financial assistance from China. And this was related with a very major scandal in the Philippines, including ZTE for the National Broadband Network. It was basically a Chinese company won this bid for a national broadband network, but the price was so bloated that it became a major thing, a major issue in the Philippines. And so when Aquino came to power, he was basically running on a campaign of anti-corruption. As a matter of fact, his focus of his political capital has been spent on peacemaking, and this peacemaking with first the Islamic secessionists and then the communist insurgents. But you can say that the Scarborough Shoal hijacked this political capital spending of the president. He is focused right now on trying to prosecute the former president as part of his anti-corruption drive, which has already resulted in the impeachment of a Chief Justice, the first ever in Philippine history. And the relationship with China has become caught in the crossfire because it has colored the president's view of dealings with China. I mean, it cannot be, because it also involved his political opponent. Another thing, but despite this, we have a young president, relatively young president, but anyway, we have a new president. He's not very experienced internationally. I think that's a better term. He still tried to come out in talks with Hu Jintao. And I remember this distinctly. He wanted to have a dialogue, private, person-to-person, face-to-face meeting with Hu Jintao in September during the APEC summit in Vladivostok. And he describes his goal as this: I want to have heart-to-heart talks with him, and so that we can discuss things in all honesty and frankness. He's not very experienced. So in spite of all these things, he still wanted to talk. But of course, at that time, the crisis was really still fever-pitch. And second, Hu Jintao was stepping down in November at that time. So I guess all this combination didn't result. One wonders if they were able to talk. I wouldn't expect much, but we don't know if it can influence the filing of the arbitration case. Another thing also is that Xi Jinping is relatively unknown. I know here in the United States, relatively unknown in the Philippines. So we have a new president, and so there's a new, and they're all trying to consolidate power. So it's not really a very good time for bilateral talks, but everybody wants to play to the galleries. So these are some of the obstacles. Okay, I'd just like to end with this list, but I'd just like to end this anyway question. That I felt that in order to solve this problem, if we cannot, we know that the legal issue cannot resolve the conflict, that's for sure. It will resolve maybe one legal issue, but then the ternary issue of the sovereignty will be there. And there is some pessimism, even in the Philippines, on filing the arbitration case. But I was saying that in order to move forward, if we cannot move forward internationally, we can move backward domestically, because I always feel that the way to move forward, to be more effective in the international arena, is to become strong in your own domestic arena. A stable government is the best ingredient for a more responsible and effective actor in the international field. So I think that the way should be really focused on establishing stronger political institutions domestically, while at the same time we continue with improving, with developing by small gains, incremental gains, in developing a rules-based regime in the international system. I would like to stand here, to end here, under pressure.
Thank you very much for our panelists. Since we don't have much time left, I would like to open the floor for the audience for questions. Please, the gentleman down there.
Thank you. Thank you for recognizing. I'm Mr. Lloyd once again from Baltimore. And I have a question regarding the presence of Americans before in the Subic Naval Base and Clark Air Base, and the Russians in Vietnam, in Cam Ranh Bay. And with the status of China right now as a rising power and number 2 economic power in the world, and evidently a leader in the region. Now, with this situation of China and the Philippines, as you said, Mr. Jimenez, that the Philippines is not a war-minded people, peace-loving, dependent on the U.S. for a long time, because the U.S. has been there since 1898, after the Spanish left the Philippines. Now, my question, with the status of China right now, do you think China would be so emboldened to bully the smaller countries in the region if the Russians and Americans are having this strong presence in Southeast Asia? Thank you.
Wow.
Yeah, quickly. No, I think, the view is opposite. I think China thinks that the Philippines is emboldened because of the FDT with the United States and the pivot to Asia. So I don't believe that, although this can be a result of miscalculation, I generally still am optimistic that it won't result in war. The last reports I've seen of the Navy Chinese aggression is that since we have smaller ships, a Chinese bigger ship would just, it's the equivalent of a drive-by shooting. They would make great waves and the Philippine ships would shake like that in the water. We didn't touch you. As Professor Wang Jing said, I can hold my hand. I can just push you with my belly because I'm big. So those are what's happening on the ground. And I hear the Navy people report about sail by. But no, I think it's more like, I've always been saying that let's also look at how they look at us, because sometimes we'll be surprised at how familiar it is.
Yes, please, the gentleman down there.
I have a question for Professor Beckman. You stated pretty categorically that China has never claimed all the waters of the South China Sea, but then it seemed like the rest of your presentation shed some doubt on exactly what the 9-dash map means. And in fact, you ended by saying the result of the Filipino filing could be that it will bring China into conformity with UNCLOS. So could you clarify that? Why do you state that China is not claiming all? I mean, how do we know that? Is it based on something they have said publicly, or is it reading between the lines? How do you come up with that?
Well, I come up with it by looking at their official statements to the UN, the statements of the Chinese foreign minister. They've made it very clear they do not claim sovereignty over all the waters within the 9-dash line. Sovereignty means you control airspace. Has China ever tried to control airspace in the entire South China Sea? Has it tried to control? Sovereignty means that no shipping can go through. Have they ever tried to control shipping? No. Their statements very clearly say we claim sovereignty over the islands and their adjacent waters. The issue is they're claiming rights to the resources, fishing rights and hydrocarbon resources inside the 9-dash line. You show me a statement where they're claiming sovereignty and I'll apologize.
Yes, the lady over there.
Okay, so this is Lieutenant Colonel Wang from National Defense University, China. My question goes to Professor Beckerman. Still with the China-Philippines case, I'd like to have your suggestion for China. If China is forced to appear on court, well, I'd like to have your suggestion that is in the best of our interest. The second, what argument can China have if China is going to present the 9-dash line claim? Thank you.
How much are you willing to pay me? I was somewhat surprised that China did not participate in the case to the extent of having a say in the selection of the tribunal and in possibly challenging the jurisdiction of the tribunal, so that even if they lost on the challenge to jurisdiction, the tribunal would be sensitized to their issues, especially on that some of the issues are inextricably linked to maritime boundary delimitation. But my advice to China in what I've written over the last 3 years is what China should be thinking about, not outside this case, is can it further its national interests in accordance with the rules of international law? Because what appears to be doing now is sending a message to states in Southeast Asia and outside the region that we are a rising power and we're going to follow the rules of international law only when it is convenient and ignore them when it is not. And if this case goes the way I expect it will go, then there's going to be a decision against China that makes their claim based on the 9-dash line less legitimate. And it will again have to reconsider whether, if it makes economic zone claims from the larger islands, that would be sufficient rather than trying to defend. In other words, I know for domestic reasons they cannot abandon the 9-dash line. I've been told that by many officials in China. But you will have to convince your public that all the 9-dash line is a rough line indicating which islands you claim sovereignty over, that you're only claiming sovereignty over the islands, not the water. But I think, unfortunately, many of your officials do not see the distinction, and now you've got yourself in an unsolvable dilemma. That's my view of the problem.
Professor. Yes, Professor Cohen.
That was one of my 4 questions. The consequences of thumbing its nose at this tribunal, and you're beginning to focus on that. And the question we got earlier from the young woman from the defense in China is close to my first question, which is, what justification should China have offered for rejecting this tribunal? Is there a legal argument that might have been more persuasive than what we've heard? Another question comes from my own experience as an arbitrator. When a Chinese party fails to show up to argue its case, what obligation does the arbitrator or do the arbitrators have to make sure the absent party's case is adequately considered? I've been in an international commercial case where China did show up to argue jurisdiction in Stockholm. It lost, and then it refused to show up on the merits. And I felt as an arbitrator some obligation to bring out what the Chinese side might have argued had they been there. I don't know what the practice of the law of the sea arbitration tribunal would be, and maybe there's no established experience with this yet. Finally, my question would be, should South Korea, Japan, the UK, or other powers interested in the 9-dash line and its scope, should they think about bringing an arbitration in order to show their concern for it? I know other countries in ASEAN are considering it. I hope Vietnam will consider it further. I don't know about Indonesia and Malaysia. They seem quite silent. But do other non-literal states have an opportunity to get in on this because they're concerned about the implications of the 9-dash line for freedom of navigation, etc.?
Let Bernie start, and I'll add to.
On the arbitration, the text of Article 9, which addresses the situation where a party does not appear, is that before making its award, the arbitral tribunal must satisfy itself not only that it has jurisdiction over the dispute, but also that the claim is well-founded in law and in fact. This means that should the Philippines decide to go forward, it would have to persuade the arbitral tribunal that there is jurisdiction, and it would then have to persuade the arbitral tribunal of the merits of its case on the merits, the merits of its, on legal and factual issues. This is standard international, public international practice. I do want to note that the dispute settlement provisions of the Law of the Sea Convention have been in effect for a long time. There have been a large number of cases. There was a case involving Japan in which Japan felt that the tribunal didn't have jurisdiction, the arbitral tribunal, and it won. But it showed up. This is the first time under the Law of the Sea Convention that the respondent has not shown up, and it is surprising. There have also been cases before the International Court of Justice where the merits of the dispute concern the Law of the Sea Convention, although jurisdiction was not based on the Law of the Sea Convention. And again, in recent years, the defendants have shown up. The practice of defendants not showing up in international tribunals pretty much came to an end in the Nicaragua case, where the United States showed up to argue that there was no jurisdiction. Now, it later withdrew from the case for other reasons, but it did argue jurisdiction. I have no doubt in this case that if China, at any point, by the way, can reverse itself and show up, but if it doesn't show up, that the tribunal will be very careful on the legal issues and will presumably do a very thorough job. One other thing I want to note, in this period earlier, prior to the Nicaragua case, where states were not showing up in the ICJ, they typically sent a letter explaining why they weren't showing up, which you and I would recognize as a highly streamlined, therefore truly readable and influential brief, because you didn't have the footnotes to bother people. And, you know, it's obvious that the court read those. In the course of the Nicaragua case, a different approach was taken in which the United States made a whole bunch of public statements. In the nuclear test cases against France, where France did not show up, this is all a long time ago. As you know, the French basically, on the basic issue, threw in the towel when their president announced that this would be the last series of atmospheric nuclear tests. Now, it is true that there was no judgment against France. The court mooted the case, but basically, France made the move. I hope that's adequate answer.
Let me take a stab at one of them. I'm not sure how China should justify the 9-dash line. I think China should consider claiming only the islands in the 9-dash line and claiming an economic zone from the larger islands. And I think that's credible and it would be consistent with the international law. terms of how you explain not participating, you might, as you like to do, use the U.S. as an example. You say issues of sovereignty and boundaries are as sensitive to China as the right to use force and self-defense is to the United States. And therefore the reasons U.S. didn't participate in the Nicaragua case is analogous to why you didn't participate in this case. But again, the question is whether you should consider at some stage moving. But if China's going to go in, one way to do it is the letter. The other way is to, before that 60 days is up, make it known you might want to have some say as to at least be consulted as to who the arbitrators would be. Whether third parties could intervene on this, or not intervene, but to bring in, I can't imagine that Japan or South Korea or anyone else who's a party would want to bring, who's not directly interested like Vietnam, would want to bring a case against China over the 9-line. I think everyone now is going to sit back and watch to see what happens, because everyone will benefit if the 9-line is found to have no being inconsistent with the convention. So I don't know why anybody else would want to try to pile on. Now there's no practice for intervention by third parties in an arbitration without the consent of both parties, and obviously both parties are not going to consent to any third party intervention.
Yes, please.
Thank you. Are we on? Richard Allison. Not a lawyer, I'm a capitalist. So my question will go to an overlap of business law with sovereign law. I'm very familiar with the development block map in the South China Sea. It's been in place for 4 or 5 decades. And I believe that there have been a number of international involvements. Does it set a precedent in one way or another that there's a direct correlation or relationship that if a foreign company bids in a power development in a block that's tendered by a sovereign, that they in fact are recognizing the sovereignty within that power block?
Whether a private company recognizes sovereignty isn't that critical. I think one interesting result of the case would be that if the 9-line is ruled by the court in Philippines' favor, then if I were advising an oil company, I would tell them to be very cautious about the CNOOC blocks off the coast of Vietnam, because there isn't any way they could be justified as consistent with the law of the sea. So it's going to cast a shadow over what China can do inside the 9-line, because there's a legal ruling that there's no legal basis for claiming based on the map, but only from islands. So it will have a practical impact. I'd expect Exxon and ConocoPhillips and all will have their lawyers looking at this very carefully.
With Total, with the U.S. companies, Marathon Oil, Chevron, does it set a precedent that these developments have already occurred? Does it presume that the tender was legitimate? Or does this territorial dispute call into question retroactively what's already existed in the way of joint development efforts?
Well, I think your lawyers you obviously taken legal advice before accepting tenders in areas that you know are controversial, so you hopefully get insurance. I don't think you could say because a company has done this, therefore what? If because ConocoPhillips does it or ExxonMobil does it, then it's recognition by the United States? No, these are private acts of private actors.
Let me just add to that. So far, there has been no experience of that sort. What happens is that the country claiming it would just grant a concession, Of course, it's just a political, well, it's a business decision now of the company whether to invest on a disputed concession block. Actually, one thing is happening there. Reed Bank, the concession was won by a Filipino. His name is Manny Pangilinan, one of the leading lights of business in the Philippines, and his partner was Enrique Razon. And Manny Pangilinan wanted to get China State Oil Company as a partner in Reed Bank. And it got into a problem with that. They even raised it when the president was in Davos. But the issue really boils down to who is going to get the royalty. And as a lawyer with a bias for negotiation, I mean, royalty is eminently negotiable. And yet, why can't anyone negotiate this? And I always trace it to the lack of trust I was earlier mentioning. That's why I'm trying to propose something like a third track or even a fourth track instead of focusing on the conflict, focusing on trade, focusing on end users. My 5-year-old is learning Chinese now because China, the Confucius Institute is spreading very, very much in the Philippines right now. Right now in the Philippines, there's the thing is you're not an educated person if you don't speak Chinese, and it's a growing belief among educated Filipinos now. The best elite schools in the Philippines now, many of them require Chinese as a language right now. Anyway, the question was, it's eminently negotiable as far as, but the problem in the Philippines is that we have a law that says that if oil is part of the national patrimony, you need congressional approval or at least a constitutional change to change the law. But even a constitutional change or congressional approval are eminently negotiable concepts. I mean, they do not represent a movable stumbling block to the problem. So it goes really back down to the very constrained, highly antagonistic, popular sentiment that is forcing our politicians to behave in a very narrow path that does not augur well for a better dialogue and a more effective international bilateral relationship. Of course, I failed to mention in the discussion is that in reality, I mean, a complete settlement of the, well, it could take 100 years, but I cannot imagine a settlement in the South China Sea dispute right now without first settling the fundamental relationship between the powers, the present power and the rising power. I mean, that is, for me, one of the more fundamental problems that smaller nations like us in the Philippines, because our fear really is this. China and the United States will never go to war. Problem is, they might engage in little skirmishes in our land.
Do we have any further questions? Yes, please.
In John McAuliffe, the Fund for Reconciliation and Development, in the recommendation that you made of claiming, just focusing on the claim of the island in the 12-mile zone, I'm unclear whether and it's the sovereignty question on these spots of land, is it considered, in fact, definitive that the current occupiers have sovereignty, or are you simply saying that that's a different issue to be resolved at a different time, that the primary real interest question right now is in these larger economic zones?
No, I think most of us that have been dealing with this issue for many years feel that the underlying sovereignty issue, when you have 5 different claimants or 4, is not solvable. We leave that to our great-great-grandchildren. You follow Deng Xiaoping's advice. You set aside the sovereignty disputes. And the underlying issue is, can we agree on areas of cooperation where we can cooperate to enhance maritime safety, to protect the environment, and to jointly develop the hydrocarbon resources and the fishing resources. But you cannot reach agreement on the areas for joint cooperation until everybody's playing by the same rules of the game. If everybody would make their claims from land territory, then we would be able to identify the areas of overlapping claims. And then we could focus on those as areas for joint cooperation. But when China's saying everything within the 9-dash line is an area for cooperation, 50 miles off the coast of Vietnam, we get to share the gas and oil, then the two sides cannot cooperate on where are the areas for cooperation. But see, I think my position on this is that China can still maintain, whatever happens with this dispute, the two fundamental principles of Chinese policy don't change. They will still claim they have indisputable sovereignty over all the islands, since time immemorial to the end of the world, whatever. And maritime boundary issues must be resolved by joint negotiation between the parties, because this case won't change that. This case, if I had to explain it to the Chinese public, I say this case will only be on minor issues of law of the sea, but our fundamental position will not change from that. And that would give you a little bit of maneuverability. But until China takes a position that we're going to claim, the assumption I've made is that some of the islands are large enough to pass the straight face test that we can say it's an island, in principle it's entitled to more than 12. It's entitled to an economic zone. Therefore, there'd be a significant area of overlap between the economic zone of Philippines claimed from its land territory and the larger islands. And therefore, that area of overlap is naturally the area you want for joint development and cooperation. So long as the Philippines might agree, so long as it doesn't include Reed Bank.
Yeah, let me just add, the irony is sometimes international law can be a driver of the problem. I mean, in the island of Palma's case, we lost a large island. It's not small like Australia. Just a few kilometers off the southern coast of the Philippines, because the U.S., in the case of U.S. versus Netherlands, the court, Judge Hoover, he was the sole arbitrator, decided that effective occupation is the best way of proving your, of strengthening your legal claim. And the case was decided on monument subtitle. The Dutch put up schools, they raised the flag, they displayed acts of government where the U.S. did not. And we lost that island. Just, I mean, if you look at the southern map of the Philippines, there's a small island there. It's owned by Indonesia. And it has, I believe, exerted a lot of influence over the massive, mad rush for occupying rocks in the South China Sea.